Section 10 deals with the contents of the specification. What should a specification contain? Section 10(1) says that every specification, whether provisional or complete, shall describe the invention and shall begin with the title sufficiently indicating the subject matter to which the invention relates. So, there has to be a description and a title. In Rule 13, the extent of the title is mentioned, in what form it should be and what should be the limitations of a title are mentioned in Rule 13. 10(2) states that subject to any rules that may be made on this behalf under this Act, and the relevant rule being mentioned there, Rule 13 is the relevant rule, drawings may and shall, if the controller so requires, be supplied for the purpose of any specification, whether complete or provisional, and any drawing so supplied shall, unless the controller otherwise directs, be deemed to be a part of the specification, and references to this Act to a specification shall be construed accordingly. So, this provision says that drawings may be supplied, or if the controller insists, they shall be supplied. So, it is optional. Supplying a drawing is an optional thing, but if the controller requires, then it has to be done. In most mechanical patents, you will find that there are drawings which explain the working, or there is a blown up view. There are different kinds of drawing or a cross section which gives an insight into how the invention works. Drawings are treated as a part of a specification, and wherever there are references to the drawing, you will find that the written part of the specification will have cross references to the drawing, and drawings shall be used, since they form a part of the specification, they will be regarded in construing the specification. So, we understand the specification as a written statement of the invention, but the written statement can also be supplemented by drawings. 10(3) talks about models and samples. The controller has the power to insist on a model or a sample of anything illustrating the invention, and once the controller insists, the applicant shall furnish before the application is found in order for the grant, but such model or sample shall not be deemed to form a part of the specification. Now, this is a critical difference between a drawing and a model or a sample. A drawing is deemed to be a part of the specification, which means if you search for a copy of the specification, you will find the drawings in it. Whereas models and samples, by their very nature, they cannot be textualized. So, understand that the drawing and the written part of the specification, because they can be textualized, they form a part of the specification, whereas models and samples, it is hard to textualize them. So, they are not deemed to be a part of the specification. A model or a sample is not insisted by the controller in all the cases, but in some specific cases. For instance, if the applicant claims to have invented a machine that is capable of perpetual motion, the controller can insist on a working sample. So, the working sample or a miniature model would show whether the invention is capable of achieving what the inventor claims. 10(4) describes the various parts of a complete specification and parts and functions of a complete specification. 4(a) tells us that the complete specification shall fully and particularly describe the invention and its operation and use and the method by which it is to be performed. So, there is a full description of the invention, and operation or use is described, and the method by which it is performed. So, the working, to put it in a nutshell, the entire working of the invention has to be described in the complete specification. B, the complete specification has to disclose the best method of performing the invention which is known to the applicant and for which he is entitled to claim protection. So, not only should the invention be described, its working shown, but the best method of performing the invention should also be disclosed. C, the complete specification should end with a claim or claims defining the scope of the invention for which protection is claimed. So, the claims should ideally come at the end of the complete specification, and they should define the scope of the invention for which protection is claimed. So, this provision tells us that it is the claims that are enforced and it is the claims that are protected. So, when a patentee files an infringement suit after the grant of a patent, it is the claims that he is going to enforce against the infringer. The person who infringes either the product or an act of the infringer will now be mapped onto the claim of the patentee, whatever the patentee has claimed. Only if the product or the act of the infringer falls within the scope of the invention as mentioned in the claim will infringement be proved. So, claims are the most important part of the specification. Claims define the scope of the invention, and it is the claims that are granted which can be enforced before a court of law. So, the descriptive part will help us to understand what is being claimed, and there are certain relations that the descriptive part has with the claim. For instance, the claim has to be fairly based on what is described. So, you cannot claim something which you have not described. So, there are some relationship between these parts, but the claims are defining part of the invention. The invention is defined in the claim, and the part that is enforced by a court of law is the claim. And when the patent office grants the claim, the patent office is granting protection to the invention in the form of the claim. D mentions that the complete specification shall be accompanied by an abstract to provide technical information on the invention. Now, what should be there in the abstract is detailed in Rule 13. The controller has the power to amend the abstract if the information provided in the abstract is not clear, or if the controller feels that by amending the abstract the better information will be communicated to third parties. The abstract is one of the parts in the specification which would be the subject matter of an initial search. Now, when the patent application is published, the details of the publication does not have the entire specification. The complete specification in its entirety is not published in the official journal of the patent office, but the bibliographical details of the invention and the abstract is published in the official journal. So, the abstract contains a technical information about the invention, and because abstract is published earlier in time, there are certain limitations on what you can mention, and there are certain word limits on the abstract. So, the abstract is probably, we can regard the abstract as the part of the patent specification which is searched first, and if the abstract is of supplies information on a particular field of technology, then the person who is searching may look into the complete specification. Now, in the complete specification where an applicant mentions a biological material, and if the biological material is not described in a satisfactory manner, and if such material is not available to the public, then the applicant shall deposit the material to an international depository authority under the Budapest Treaty. Now, this is a requirement which steps in only in the case of biological material that is used. The requirements are, if the biological material is not described in a way in which it satisfies clauses A and B, and the biological material is not available to the public. These are the two conditions. One, it is not described in a way which described in clauses A and B, that is where there is a detailed full description of the particulars and the best method of working. And if the material is not available to the public, then there is an obligation on the applicant to deposit the material to an international depository under the Budapest Treaty. Now, the deposit of the material shall be made not later than the date of filing the patent application in India, and a reference thereto shall be made in the specification within the prescribed period. So, not only there is a timeline for making the deposit, a reference also has to be made in the specification within the prescribed period, which is again mentioned in Rule 13. And there are some requirements, as the specification shall include the name, address of the depository institution and the date and number of deposit of the material at that institution. So, once the biological material is deposited, there is a date on which that is done and a number which is given. So, those details have to be included in the specification. And access to the material is available in the depository institution only after the date of the application for patent in India, or if the priority date is claimed after the date of priority. So, the access, if anyone needs to access this material, that is allowed only after the date of application of the patent or after the date of priority. And the applicant also has to disclose the source and geographical origin of the biological material in the specification when used in an invention. So, if it is a plant variety which grows only in a particular country, then the applicant will mention the source from which the biological material was derived, and it will also mention the geographical location. 4A tells us that in the case of an international application designating India, which includes a convention application and a PCT, the title, description, drawing, abstract and claims filed with the application shall be taken as a complete specification for the purposes of this Act. Now, 4A actually tells us what are the critical parts of a specification, or what comprises a complete specification: title, description, drawings, if there are any, abstract and claims. So, these 5 parts comprises the complete specification. So, the complete specification will have a title followed by a description, and the description will have cross references to the drawings if there are any drawings, and the drawings will also be there in the complete specification in separate sheets. There will be an abstract of the invention again in a separate sheet, and claims beginning in a separate sheet. So, these parts together form the complete specification. Subsection 5 of 10 states that the claim or claims of a complete specification shall relate to a single invention. In section 7, that there is a cross reference to section 7 which tells us that an application can be only for a single invention. So, there can only be one invention. So, this reiterates that the claim shall, or the group of claims shall relate to a single invention or a group of invention linked so as to form a single inventive concept. So, this is called the unity of invention. An application should pertain to only one invention or a group of inventions that are connected by what is called a single inventive concept. There are a group of inventions, but they together have the same concept. 5 also has another requirement, that the complete specification shall be clear and succinct and shall be fairly based on the matter disclosed in the specification. The fact that the complete specification should be clear and succinct is a requirement that the complete specification should not be ambiguous and it should communicate the invention clearly. So, if there is any ambiguity, or if there are words that are not clear, or words that are capable of multiple meanings, words that are ambiguous or vague, then those can actually come in the way of the grant of a patent. So, the fact that the patent is granted implies that the patent clearly and succinctly communicated the invention. Apart from the fact that the claims of a complete specification shall be clear and succinct, clear and succinctness is a requirement for the claims. The claims shall also be fairly based on the matter disclosed in the specification. This concept is called fair basis, which states that the claims are based on what the matter that has been disclosed in the specification. This requirement is critical because a person cannot make a claim of something that he has not disclosed. If the applicant has not disclosed a part of the invention, then it would not be proper on him to claim it without making a disclosure, because as we have already seen in clauses A and B of section 10(1), that the descriptive part has to be full and particular description. It has to disclose the best method of working, the operation or use, and the method by which it is performed. All these things have to be described in the complete specification. If the descriptive part does not make a full description of the invention, and if you claim something which you have not described, then the patent office will regard that your claims are not fairly based on the matter disclosed, and that will be a ground for rejection of the claims. Now, we can understand this, that if you make a prayer or a petition before an authority or a court of law, normally your petition will end with a set of prayers, relief that you seek in the court of law. If it is a relief against trespass into your property, then you would claim a relief of injunction, injuncting the person, the trespasser, from entering into your property. You are not going to make this claim, you are not going to seek this relief of injuncting the third party against whom you have filed a suit from entering your land without describing an instance of trespass, or at least describing an instance of where there has been a threat to trespass into your land. The relief that you claim, the prayer that you make in your petition, has to flow from what you have pleaded in your petition. So, if you make a prayer without the corresponding pleading, most likely the court will not grant you the relief. Similarly, you cannot claim an invention or a part of an invention which you have not described in the descriptive part of the specification. So, the concept of fair basis tells us that every claim should be based on a description in the descriptive part of the specification. The description should disclose the claim, or the claim should flow from the description. Now, this has also led to certain techniques in patent drafting to ensure that you don't claim something which is not fairly based. Some attorneys draft the descriptive part first and then they try to map it with the claims, or the attorneys who draft the claims first, that is another approach in patent drafting, will ensure that the descriptive part has the objects that have been claimed described in detail. So, either way, whether you follow the method of drafting the description first and carving out the claims, or drafting the claims first and working back on the description, in either way you are going to ensure that the claims are based on the description, to get over this objection that which could come from the patent office in case if the claims are not fairly based on the description. Subsection 6 says that the declaration as to inventorship of the invention shall, in such cases as may be prescribed, be furnished in a prescribed form with the complete specification, or within such period as may be prescribed after the filing of the specification. Now, we saw this, the proof of right in the case of an assignment could be filed either at the time of filing the complete specification, at the time of making the application, or after a time period that is prescribed. And we saw that the time period that was prescribed was 6 months from the date of filing the specification. So, there was an option. So, there are documents that go along with the form 1 and form 2, and if you look at the form 1, the concluding part of form 1 tells you what are the documents that has to be accompanied along with the form 1. Form 2 in all cases is accompanies the form 1, and a declaration of inventorship should also accompany the form 1. If it is not filed along with the complete specification, then it has to be filed within the period that is prescribed. A declaration of inventorship is filed using form 5. There is a separate form for that. Subsection 7 states that subject to the foregoing provisions of this section, a complete specification filed after the provisional specification may include claims in respect of developments or additions to the invention which was described in the provisional specification, being development or additions in respect of which the applicant would be entitled under the provisions of section 6 to make a separate application for a patent. Subsection 7 says that if there is a complete specification filed after a provisional, then all the developments and additions that happen to the invention in the interregnum, in the period between the filing of the provisional and the complete, can also be claimed in the complete. So, there is no need for the applicant to file a separate application for that, though he would be entitled to do it. But since there is a time period between the provisional and the complete, all the development that happened after the filing of the provisional could also be included in the claims of the complete. Without doubt, those claims which were included later on will have a different priority date, and we had mentioned that claims will have different priority, and the priority date of the claim the date on which the claims are filed for the first time or disclosed to the world for the first time, the priority date will start from the date on which the disclosure was first made. So, if a part of the claim filed with the complete specification was disclosed in a provisional, then the date of the provisional will be the priority date for that claim. If that claim was filed only in the complete and it was not disclosed in the provisional, assuming that there is a description that goes with the claim in the complete, then the date will be of that of the complete. To give you a better illustration, if the provisional was filed on January 1st of a particular year, which has a mechanical device, and in June 1st complete is filed for that invention with the claims, but when the complete is filed, there is also an additional device or an additional component that is added to the invention which was not described in the provisional that was filed in that year, then that additional device which was filed in June will have the priority in June because it was not disclosed before, whereas the main device which was disclosed in January will have its priority from January, though the claims appeared only in the complete specification that was filed in June. So, this is where the fair basis, the concept of fair basis comes in. The claims that are filed in a complete specification, so far as they are fairly based on a disclosure mentioned in a provisional specification, the claims will get the priority of that disclosure. So, subsection 7 tells us that once a provisional specification is filed and the provisional specification is followed up by a complete, any development or improvement or addition made after the filing of the provisional specification can be claimed in the complete specification, but it will have a different priority date. Now, many of the requirements in section 10 that the complete specification shall describe the invention, there shall be a full and particular description of the invention, there shall be a disclosure of the best method, the claim shall define the scope of the invention, that there shall be only one single invention per application, that the claim shall be clear and succinct, and the claim shall be fairly based on the matter disclosed. These are all requirements that the patent office insists before filing a patent application. Assume a case where a patent application goes through the patent office, is scrutinized for all these things and gets granted, and due to oversight some of these requirements, like the claims are not clear and succinct or the fact that it does not disclose the best method, the patent office overlooked them and granted the patent. These requirements, which what we call as requirements that a complete specification has to satisfy, will now become grounds for revocation for a patent to be challenged because these requirements were not satisfied at the patent office. So, the fact that the claims are not clear and succinct could be a ground for revocation. The fact that the claims are not fairly based on the disclosure could become a ground for revocation if that patent got granted with that defect. The fact that the best method is not disclosed could become a ground for revocation. So, if you look at some of the grounds in section 64, some of the grounds are actually the requirements which have to be met by the applicant. If they are not satisfied before the patent office, they could become a ground for revocation later on before the appellate board or the high court. Some of these grounds could also become grounds for opposition after a patent is granted.